Number 1.
This is a appeal method. Current finding.
What's wrong with the judgment?
They have rejected our Jamabandi method. Or Jamabandi method.
No.
The Jamabandi, it is after my lord resettlement operation, this Jamabandi is just prepared method. So it gave the title method. And post method in mutation, office mutation, non-settlement area, it cannot be a title method. But after settlement operation, it was
Your title has been shown on the basis of the Jamabandi.
yes, or my ancestor, my ancestor. I have inherited from my mother, grandmother. So her name is Diyar, and they have stated that they have purchased. They did not use the evidence of their vendor. They also
That is defendant. We are not concerned with the defendant. We are concerned with the plaintiff.
yes,
And the plaintiff has proved his title only on the basis of the record of rights.
yes,
Then?
record of rights. The record of created after the settlement operation. After a field mutation, this settlement operation, name of the Patajari is Diyar Miller. So it is Miller, good title Miller.
What is that?
But my lord, Umiyabola Dotto, they take it up.
That is Jain Sharma?
Yes, that is
But what do you take, how do you take care of the judgment of the Supreme Court wherein it says, 2013, categorically says that the record of rights cannot be the basis?
and of revenue. That is answered here also, Miller. Here also. That there is a different land revenue regulation regarding that Punjab matter, Miller. So our land revenue is different, Miller, after 1886, Miller. So after preparation, Miller, may I read the para 7, Miller? Para 7 of the judgment.
No, what is the only, you only produce that document. What are the other documents did you produce? Exhibit. Huh?
Oral evidence is there, Miller.
Oral evidence you can't put.
But that was rejected because it is only a revenue entry. But revenue entry is two types. We have specifically pleaded here that two kind of revenue entry. After settlement operation, the entry, well course during non-settlement area. Settlement period entry is made, which cannot create a title. There may be dispute. But it is
What are the exhibited documents? Let us see.
here we have my lord exhibit 2, my lord. Our exhibit is Jamabandi, my lord.
That I have seen it, but other documents which you have exhibited. And the Jamabandi only stated the names of your ancestors, not
Yes.
yours.
I am the heirs, that was not disputed, my lord.
So, but your name was not inserted.
Not in settlement.
Then,
But I am the heir, my lord. So my ancestor name here. So I am inherited by of necessarily.
no, in the meantime, you may have sold it.
That it will reflect, my lord, if this settlement operation, my lord, or
May not be. That may not have been
that was not,
mutated.
my lord, the case that my ancestor is not land with the army. They have not stated that we have executed those documents, my lord. The basis of we claim, my lord.
Understood. But if it is a Jamabandi, understood, there might be a question. It may
Might be,
show
my lord.
that
Yes,
it is a prima facie only a case, a revenue entry is only for the purpose of collection.
yes, my lord.
So
That is
can
yes.
that be a, why not do you, yes, there must have been a patta issued in your favor of the ancestors.
But probably in different places of the Assam, Patta was not issued, my lord, but record is there, my lord. After settlement is there record of right. In some places that Patta is issued, my lord.
Was the settlement order produced?
Settlement, my lord, that is my lord, Jamabandi itself, my lord. His name is entry. That entry is, my lord, where
Where is the Jamabandi?
not annexed, annexed to exhibit 2.
Being on record by filing an additional application.
If possible, my lord,
Counsel,
other
counsel for the appellant seeks for an accommodation to bring on record two by filing an additional matter immediately after. Before vacation,
after vacation, we have to collect, my lord. Personal question also there, my lord. It's a personal question of lord is again section 6 title suit was considered.
that is immaterial. That is, I've seen it now. That is immaterial. The first and foremost is, did you prove your title?
Connect, yes, my lord.
If you prove your title, whether other things
Yes, ma'am.
happen or not, that is immaterial.
My lord, Dashti service already been taken for order of the Honorable.
It's seen from the affidavit of service so filed on 1st of May 2024 that the respondent number 1 had duly received the service by putting his signature. Accordingly, this court deems that the service upon the respondent number 1 is complete. Who is respondent number 1?
Number one.
Who received this? Ujit
Yes.
Tati, who is he?
He is the staff of the office of the
Huh?
company. He is the staff of the office of the company.
Can't give it to a staff. It's
Yes.
a company.
Tea state, my lord.
No. It's tea state or whatever may be. First of all, it has to be it is a company. Limited. Hengalberry Estate Limited is
Yes,
a
my lord,
company.
but in the office it was received.
So
Yes.
it can't be received. Can it be received under Order 29, Rule 1? Have a look. Order 29, Rule 2.
For the first time they refused to receive. Thereafter,
The
My- my-
Talukdar
my client-
kindly look into Order 29 Rule.
person so authorized may act personally or appointed pleaders.
Oh, 29(2).
29(2). So person stood by against military or enemies. Hanged. Yes, my lord.
What does he say?
Any person authorized by an officer, soldier, airman to prosecute or defend a suit in his state may prosecute or defend in person in the same manner as the officer could do if present, or he may appoint a pleader to prosecute or defend the suit on behalf of such officer. The office of the T state, it was received. Not an
No, number 4. Order 29. Yes. Service on corporation.
Yes,
29.
yes.
Subject to any statutory provision regulating service where a suit is against the corporation, the summons may be served on the secretary or any director or principal officer by leaving it or sending it by post so and so, then how is this service? Can I have it service like this? And you are putting it represented by the manager. Why didn't you put it to the manager?
My lord,
And you don't know, you have not also stated out here who is the person concerned. Kindly see what you have mentioned. That AR has been upon respond number one and the respondent acknowledged it. Who is respond number one? How can this Tati be a respond number one?
but that Tanglabara is the statement is the
Then-
number
This is not done. Mr. Leho. This court have duly taken note of the affidavit of service filed on 21/5/2024 by the appellant, by the petitioner. Gusto. It is seen that the respondent number one is a company. Under such circumstances, and more so, the respondent number one has been shown as the manager, has been shown as represented by the manager of Idobari Tea State, Tiok Ghat. Gusto. Be that as it may, the person who has received it is one Ojit Tati. But it is not known who that person is. Under such circumstances, this court rejects the justice service submitted upon the respondent number one. Be that as it may, for the interest of justice, a further chance is being given to effect service by way of justice upon the respondent number one. The instant proceedings is therefore directed to be listed again on 5th of August. Interim order passed earlier shall continue. The justice service again has to be routed through the registry of the court and an affidavit be filed on or before the next date.
It is your lordship. Justice service has been effected, lordship, and affidavit has been filed. The served on 26/5/2014, 24, lordship.
Imran Hussain,
Yes, lordship.
who is the
The respond number one claimant, lordship.
Berda ICICI.
Yes, lord.
There, it was fixed for judgment, nah?
It was fixed for, in fact, lordship,
It was fixed for judgment, if I'm not wrong.
yes, argument, then judgment, lordship.
The judgment is not delivered.
Statement, lordship.
You placed it before the court.
Yes.
Court have duly taken note of the affidavit of service so filed on 18/6/2024. And on the basis thereof, it seems it is a court deems service upon the respondent number one to be complete. However, none has appeared on behalf of the respondent number one in call. Be that as it may, for the ends of justice, the matter stands adjourned again to be listed again, to be listed on 19th of July 2024. Thereby enabling the respondent number one to put in his appearance if so advised. The interim order passed on 15/5/2024 is extended till the next date.
Much obliged.
9,
direct T modes, visual, post, third post as well as those T
The Dosti service report we have received, my lord, we are likely to file a affidavit, my lord, today.
You have effected service?
My lord, we have taken step in all three modes, my lord. Dosti service report, my lord, will file today an affidavit. my lord. But
Oh, you have not done it?
Hello.
The service is also not complete. Here it says the unserved notice received back postal note addressee cannot be located, kept in so and so
Hello.
service upon the response.
Dosti
Usual
service,
person not yet
Dosti
received.
service is done, my lord.
Oh.
Got the report, my lord, we will file an affidavit today. my lord.
Then how can we fix another date? Mr. A.R. Sigdar, the learned counsel appearing on behalf of the petitioner submits that the dusty service has been duly effected. However, the affidavit of service would be filed during the course of the day. Taking into account the above, list the matter again on 22nd of July 2024. In the meantime, the registry shall bring on record the said affidavit of service. The interim orders were passed on 15/5/2024, stands extended till the next date.
Biplab.
Yes, what is this?
Lordship, this application, I application, Lordship,
I for what?
I for substitution, Lordship, the legal years of respondent number one.
Within time?
Lordship, within time, there was a delay, Lordship, but that time was excluded. So that is why, though we have filed an application for section 5 and setting aside, when there has been,
Who died?
Lordship, the respondent number 1 and 2. Ranjit Nag and Dijit Nag, Lordship.
This is an application under Order 22, Rule 4 of the Code of Civil Procedure 1908 for substituting the legal representatives of the respondent number 1 and 2 who expired on 19/6/2020 and 6/5/2020 respectively. From a perusal of the office note, it reveals that the said application so filed is within time. This court also takes note of that the respondent number 1 and 2 who expired is survived by their legal representatives whose name duly appears in paragraph number 2 of the instant application. Accordingly, this court also takes note of that the right to sue survives upon the legal representatives of the respondent number 1 and 2 who expired. Accordingly, this court allows the instant application by substituting the respondent number 1 and respondent number 1 by the names appearing as serial number 1 Roman 1 and 1 Roman 2 at paragraph number 2 of the application, and the respondent number 2 by the names mentioned by the persons whose names are mentioned at serial number 2 Roman 1 and 2 Roman 2 to paragraph number 2 of the instant application. They shall be arrayed, the newly substituted respondents shall be arrayed as respondent number 1 Roman 2 against the original respondent number 1, and 2 Roman 1 and 2 Roman 2 against the original respondent number 2. I stands disposed. Yes, Mr. Rajbal Bhuiya, you're appearing for the new ones. Okay. Huh?
As regards 1 and
Okay, you accept notice of the, okay. Mr. It's Rajbol Bhuiya, the learned counsel, who represents the respondent number 3 and 4, also submits that he has instructions to appear on behalf of the newly impleaded respondent numbers 2, 1 Roman 1 and 1 Roman 2. Hey, I got to the counsel for the applicant is directed to applicant is directed to file a fresh memo of parties before the registry of this court within 3 days, and thereupon the registry shall make necessary correction of the records in the records of the accompanying second appeal, and also update the same in the CIS. Mr. M.H. Rajbol, the learned counsel, appearing on behalf of the petition, appearing on behalf of the respondent number 3 and 4, submits that he has also been instructed to appear on behalf of the newly impleaded respondent number, substituted respondent number 1 Roman 2 and respondent number 2 Roman 1 and 2 Roman 2. He submits that he would be filing his power within 7 days from today. Taking into account the above, the service being complete, this court fixes the instant appeal for hearing in its usual course. Liberty, however, is given to the parties to mention the matter liberty, however, is given to the parties to file appropriate application for early listing of the appeal. Sir Rajbol Bhuiya, yesterday you should have withdrawn that appeal. While going back and seeing that order, you should have withdrawn that appeal. This not withdrawing the appeal will affect your client a lot. What say?
Initially, I was.
May man kinu na daw? Ikaw not? Yes, what is this?
This
For what?
an injunction application.
What is
lordship.
this application?
Injunction, lordship.
Who is asking for injunction?
I am asking for injunction. Already status quo was granted on last.
Affidavit, you file your affidavit. Interim order passed earlier shall continue. Now, what do you want? Not to construct. Who won the appeal?
Lordship, we are the appellants.
Actually, partly allowed, madam.
Already status quo, only he needs some more time, lordship, may come after vacation.
Which one?
IA, lordship.
For what?
Injunction already status quo was granted, lordship. Our respondent wants to file an objection, lordship.
He has already filed an affidavit in opposition on 18/6.
No, lordship. That IA was withdrawn.
Earlier one was, I was there.
Okay, Mr. D.C.C. Pukon, the learned counsel, appearing on behalf of the respondents, submits that no, you were supposed to file within 15 days. Then why didn't you file it?
Earlier was, not after this.
I'm not, yeah, you were supposed to file it. We make it absolute. You didn't file it. Who is constructing? Hmm.
I am constructing from.
Hmm. Hmm.
That's why they.
Hmm. Understood. If it is in your position also, why should you? Let the appeal be disposed of.
My lord,
Don't construct.
I-
I gave you an opportunity. You failed to do so. You impose cost on the listing of the matter. 5,000. Let it remain. We do one thing, Mr. Pukon. No. What they have done. The courts below were justified in dismissing the entire suit of the plaintiff without taking into consideration that the plaintiff had ownership rights over the land described in Schedule A. The courts below the suit of the plaintiff. Now you are saying that he is constructing in Schedule A.
Schedule C. C land, Lordship.
C.
C.
See, you have no business.
I have prayed for recovery of Lordship schedule.
No, here the question of law is only in respect of Schedule A.
A Lordship, it includes schedule C.
Schedule A includes Schedule C. How do you say so?
Lordship, page 20 of memo of appeal, schedule C is another part of schedule A land of the plaintiff, of which the plaintiff in respect of which recovery of.
You are the
funds-
plaintiff.
Yes, Lordship. Schedule C is under their possession, Lordship. They are constructing, so recovery was sought for by the plaintiff.
What are they constructing? So what are those photographs?
Already status quo granted, Lordship, then. Status quo, Lordship.
Let the status quo remain. What is there? What is there to file objections? We gave you enough time for that. Oh, they are asking for recovery. Tomorrow you make a 5-story building, then? Why are you asking for C and D?
Lordship, I am prepared.
Okay. Hello. We do one thing.
Lordship may fix it for hearing after vacation.
We vacate this stay and fix it for hearing after vacation.
Till then, Lordship.
Okay, Mr. DCC Fukan, the learned counsel appearing on behalf of the respondent opposite party seeks for a further accommodation for filing the affidavit, the reply, objection to the injunction application to establish the matter again on 29th of July 2024. The objection, if any, be filed on or before 25th of July 2024. Full stop. And the interim order passed earlier shall continue till the
Yes,
disposal of the instant miscellaneous application.
Apply.
My lord, the
What is this?
service is complete and record has been received. But that I has not been disposed of. I on the order for five. Service complete.
Question of law framed.
Fine.
Now you want to stay.
Order 40 on rule 5, I have filed. That has not been disposed.
The executive decree. What is the decree passed?
Recovery of position.
Recovery of possession. Hello. There is no stay.
So no still.
Understood, but we have to state. It's a executive level decree and questions of law have been framed. Courts have come.
Fine.
This is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908 for staying the operation of the judgment and decree dated 16/9/2023, passed by the learned District Judge Borpeta in title appeal number 11/2020. This court have duly taken note of that on 6/12/2023, this court had already admitted the appeal by formulating 3 substantial questions of law. Full stop. taking into account, and this court also takes note of that the records have also been received. So under such circumstances, as the decree which have been passed is an executable decree, and this court is in session of the dispute in view of the admission of the appeal by formulating substantial questions of law. It is the opinion of this court, and this court therefore stays the impugned judgment and decree dated 16/9/2023, passed in title appeal number 11/2020 by the Court of the Learned District Judge, Borpeta, till the disposal of the instant appeal. I stands disposed. A main cannot legible. This court have also taken note of, heard Mr. So-and-so, the learned counsel learned counsel appearing on behalf of the appellants, and Mr. M. Dutta appearing on behalf of the respondents. The service is duly complete. The records have also been received. Accordingly, list the matter for hearing in its usual course. Liberty is given to both the parties to file applications for early hearing of the matter.
Five.
Yeah, please, your lordship. Yes, your lordship, service is not yet complete, your lordship, as per office note dated 19/6/24.
What is this I for?
Condemnation of delay, your lordship,
How much?
90 days. Your
90 days. Service not complete.
lordship.
Service not complete. As such, list the matter for
Lordship,
list the instant application only upon completion of service.
the lordship would like to take fresh step on this.
The learned counsel appearing on behalf of the applicant submits that in view of the service having not been complete, and the applicants would like to take fresh steps upon the respondents. First of, he is given in that view of the matter, the applicant herein is directed to take steps by way of registered as well as usual upon the opposite parties herein, opposite party by respondents, respondents herein within 7 days. List the matter after completion of service.
Six. I also filed this IA for state of Garganum decree.
For
Garganum decree passed by December.
they
Yes. Yes, 16 lost by Kyle.
appeal admitted.
Yes, I believe.
Question of law frame.
Yes.
Oh, yes. Oh, you filed it later on.
Yes, sir.
I
Because
told you.
you lost of page 16, you lost a pass and order, page 16. Earlier, there is a interim order.
লেখক এইটো আগৰটোৱে লিখি দিব এটা যে বস্তু দিলো হা অৰ্ডাৰ ফৰ will five এখন হা খালি জাজমেন্ট এণ্ড ডিগ্ৰী ডেটেড so and so ঠিক আছে তো বদলি যাব 35/2017 পাস না 29/5/2018 in title appeal number 25/2007 এইটো হ'ব আৰু records have not been come and main case to এটা বস্তু দি দিব that service is complete.
Complete, my lord. Service complete.
Service complete. Huh?
Accepted. The performer dependent or deleted. They are not contested this week.
And the council who represented the respond number 1 to 5 in the condonation application. There is nobody else. Huh? Other persons we strike off if necessary. These matters unnecessary should not be there.
They are
6 to,
performer dependent.
who are these?
They are performer dependent.
We strike out.
Already strike off.
Huh?
Already strike off.
Strike off.
Petition, their name already.
There is no striking off. We strike off. Mr. Imin to Dibo, Mr. So-and-so, J. Ahmed, the learned counsel appearing on behalf of the respondent, appellant submits that the names of the respondent number 6 to 18 may be struck off, taking into account that they are performer respondents
Cannot contest. the
and they have not who have not contested, never contested in the trial, as well as in the first appellate
test.
proceedings.
And some of the already received notice not appear.
Not necessary. Under such circumstances, he therefore submits that their name may be struck off. Taking into account the above, the names of the performers to 18 are struck off. This court duly takes note of that the service upon all the remaining respondents are duly complete. Accordingly, however, the records have not been received. The registry is directed to take appropriate steps so that the records are received at the earliest. Thereupon, the matter be listed before this court for orders. I disposed. Okay.